So, Professor Lund, what I'd like to do, if we could, is set the stage for the students in our conversation. So, as you know, there's been a, starting in 1990, kind of a, what we could argue is a sea change in how the Constitution treats the free exercise of religion and what protections it provides it and what the test should be. And ever since that sea change, the Supreme Court and lower courts and scholars have been trying to figure out precisely how we should define that protection for the free exercise of religion, what its limits should be, right? And we've seen a lot of developments in recent years on the court, especially after the pandemic. And so you've got what I think is one of the latest and best articles on this, describing where the court is and what are the implications of the various tests that it has now adopted. And so I wonder if you could set forth what those tests are, help our audience understand that, and then argue some of your thesis about what the limits are and some of the potential weaknesses are of that test.
Yeah, thanks, Steve. Yeah, I'm pleased to be here, to be working on these issues. Steve's an authoritative voice on this, Professor Sepper, who's in the audience as well. Maybe just to unpack it all for those who aren't familiar with this. But the First Amendment has two provisions related to religion. The Free Exercise Clause, which entitles people to practice their religions, and the Establishment Clause, which restrains the government from practicing religion. And the decision in 1990 that Professor Collins was talking about was this case called Employment Division versus Smith, which involved the religious use of peyote by members of the Native American Church. And before 1990, I guess starting in around 1963, the Supreme Court had adopted what you might remember from constitutional law as a strict scrutiny test, right? A compelling interest test for religious exercise. The court gave religious exemptions, sometimes in sufficiently sympathetic cases. It did so under this strict scrutiny test where substantial burdens on religious exercise had to be justified by compelling governmental interests. There's debate about how strict this test was. I think it was Professor Sager, right, who said that it was strict in theory and
feeble in fact.
Feeble in fact. That's right. Turning the old phrase, fatal in fact, on its head. The case you might remember from this period, if you remember any of them, involved the Amish and the requirement that they educate their kids in the Wisconsin schools until the age of 16. The Amish successfully got a religious exemption so that they could pull their kids at the end of 8th grade, which would have been around 14 or 15, saving them the last 18 months of school. And the court said, denying them an exemption would greatly change their religious way of life. It puts a real burden on their religious exercise, and it's not justified by any compelling governmental interest. The big change that Steve referred to happened in 1990, where the court decided Employment Division versus Smith. That, again, was the peyote case. And in that case, the court effectively said no exemptions, or at least exemptions in very limited circumstances. As long as the law is neutral and generally applicable, that is, as long as it was passed without any kind of discriminatory intent, that's what neutrality means, and as long as it applies to mostly everyone, that's what general applicability means, then the law is fine, and therefore the court said no exemptions for the Native American Church seeking to use peyote. Smith was rejected by a lot of people at the time. Congress sort of changed it a little bit with the Religious Freedom Restoration Act, which was passed 3 years later. Although that was struck down in part on federalism grounds a few years after that. RFRA now applies to federal law, but it doesn't apply to state law. Basically, most religious liberty disputes, most free exercise disputes happen at the state and local level. I think that's true to say, still true to say, although maybe that's changing too. And at the state and local level, the RFRA doesn't apply, and so unless the state has its own RFRA, these things are all handled under Employment Division versus Smith, which says no religious exemptions. And at least that's the way things stood until maybe about 5 years ago, where the court has really returned to the free exercise, as if it was hungry for it. The court's decided more free exercise cases in the last 5 years than it had decided in the previous 25. The court's really passionate about this. It sees religious liberty as in deep jeopardy, and the court wants to protect it. But how it's protected, I think, is sort of fascinating, and it's kind of the heart of this article. The court could have gone back on Smith, and there are people on the court who would go back on Smith. 3 justices have said that they would overrule Smith. 3 other justices have said that they're interested in overruling Smith, but they don't know how to go about it. But in the last 5 years, the court has managed, despite having an official rule against religious exemptions, it's managed to give religious exemptions in case after case by developing a really conceptually elaborate conception of what counts as discrimination, right? It's taken this neutrality and general applicability requirements and really, invigorated them. At the time, it seemed like in Smith in 1990, it seemed like neutrality and general applicability would mean that free exercise cases basically went away, that religious exemptions went away. It seemed like almost courts rubber stamping legislative decisions. But in the last 5 years, the court has really invigorated these concepts in a bunch of ways that we might talk about, to the point where it's becoming hard almost for religious observers to lose cases. Even though we have still this rule that says they shouldn't win, or at least their wins should be very exceptional.
So let's talk about that. Let's talk about general applicability, right? So, I mean, in Employment Division versus Smith, some people may be surprised to know in 1990 that was written by Justice Scalia and what was then the conservative majority of the court. And Scalia didn't see it necessary to define what he meant by a law that is neutral and generally applicable, right? So he says, if a law is neutral and generally applicable, generally it's okay if that burdens someone's exercise of their religion. Now we spent the last 33 years trying to figure out what does it mean for a law to be neutral and generally applicable, and the way, as you say, the way the court has analyzed that, it seems like it's almost impossible now for a law to be generally applicable. I mean, would you say that's fair?
Yeah, I mean, in some ways, maybe that overstates it a little bit, but I mean, that's a good first cut at it. In Smith, the peyote rules, the court said, were neutral and generally applicable. That wasn't the result of any kind of analysis. The court didn't talk about what neutrality or general applicability meant. It was almost just a way to make the case go away. I mean, this law, peyote laws apply to everyone. I mean, they don't actually apply to everyone, but they apply to mostly everyone. Again, the court didn't say any of this, we just sort of assumed it. But 3 years later, there was a different case, a case about animal sacrifice called Lukumi. And in that case involved, the city of Hialeah and a group of Cuban Santeria practitioners who wanted to sacrifice animals in their religious worship. And here the court turned back to the concepts of neutrality and general applicability and really sort of fleshed out their meaning a little bit more. The court said that the laws burdening the Santeria, they were not neutral, and they weren't generally applicable. They weren't neutral because they had been passed with discriminatory intent. The object of the law was to burden the Santeria practices. This wasn't a bad thing, but a good thing in the eyes of the people that passed the law. And the court said the laws weren't generally applicable, right? You forbade the Santeria from sacrificing animals, but the state of Florida allowed animals to be killed in a wide variety of other contexts. Like for food consumption, most obviously, pet euthanasia, fishing, kosher slaughter. I mean, hunting is a constitutional right in Florida. It's a felony in Florida to help an animal escape a hunter that's lawfully pursuing it. I mean, Florida's not a big animal rights state. But they were enforcing the law against the Santeria, the court said, and you're not enforcing it against all these other people. You've made exceptions for them. You need to make an exception for the Santeria too. So this is the way it sort of slept at the Supreme Court for 20 years. Right? You had Smith on the one hand, the law sort of clearly being generally applicable. Peyote laws definitely do apply in almost every, conceivable application. And the rule over in Lukumi seemed like Swiss cheese. There were sort of exceptions for all kinds of non-religious killings of animals. And there was this huge gray area in the middle. And it was unclear what neutrality and general applicability required. Some courts said, well, really, we just think it's a ban on intentional discrimination. That's really what Lukumi was. Other courts, though, began to develop a really robust theory of general applicability, which maybe brings us, I think, to Judge Alito's decision in this Newark case. This happened before he was on the Supreme Court. It happened when he was on the Third Circuit, where 2 Muslim police officers wanted to wear beards. But the police department had a rule saying essentially that all officers had to be clean-shaven. The rule looked neutral and generally applicable. It seemed to apply to all police officers. It seemed like you shouldn't get a religious exemption. But there was an exception in the rule for officers with medical needs. Officers with medical needs didn't need to shave, and Judge Alito, with this very expansive, powerful notion of general applicability, said, well, this is discrimination, right? If you're going to allow medical officers to be exempt from the rule, or officers with medical needs to be exempt from the rule, you need to allow religiously motivated officers to be exempt too, right? This is just a tiny exception. In fact, I don't even think it was clear that it had been used, very often at all. The exception was mostly hypothetical, but the court said Judge Alito said it required a religious exemption, and I think thinking about Newark hard can lead to a lot of sort of interesting things that maybe I'll bring out in just a little bit.
Right, so I'm thinking we have a world with the Lukumi case, the animal sacrifice case, where it seems like the only people the rule applied to were the religious folks. And then you've got Judge Alito making the case that even one secular exception to a rule makes it not generally applicable.
Right.
And if it's not generally applicable, then government has to have a compelling reason for why not. Now he says that as a circuit court judge. It's not adopted by the Supreme Court. They basically got Smith and Lukumi sitting out there and have not provided much of a definition since then. And then we end up with Masterpiece Cake Shop and the COVID cases and Fulton, where suddenly this idea of general applicability and neutrality are starting to get really defined by the court.
Right.
And so that's, I think, the thrust of your article is this later definition of general applicability, where the court essentially has adopted Judge Alito's view of this, right?
Yeah, that's right. The court, I think, officially adopts Justice Alito's view in one of the COVID cases in Tandon versus Newsom, where, this rule seems very generally applicable. It doesn't seem like it discriminates against religion at all. California has a rule basically limiting the size of in-home gatherings. I'm trying to remember the actual facts in Tandon. COVID says you can't have in-home gatherings. Except you can have in-home gatherings of people who aren't related to each other of up to 3 families. And that's the rule. And the court says, well, that's the rule, and it means that you can't have church gatherings of more than 3 families either, except the fact that you've exempted businesses from this requirement, right? From this, 3 families rule, right? Nail salons and supermarkets and other kinds of businesses have a right to be open. And if you allow these other businesses to open, then you have to allow in-home gatherings, religious gatherings of more than 3 families, even though the ban on in-home gatherings seems very generally applicable, right? It applies to religious groups the same way it applies to non-religious groups. It's sort of this exception in another law, right? Or maybe it's all the same law that justifies or requires a religious exemption here. And the court takes that idea from Newark, right? That if you make just one secular exception, if that secular exception does the same kind of harm as a religious exception would, you have to make a religious exception.
Now let me ask you, let's for the Professor Vladeck fans in the audience and to get him all worked up, let's ask a question here, okay? Tandon is a shadow docket case, right? So the question then is, has the court truly adopted the rule that one secular exception makes a law not generally applicable? Or can we dismiss that as being a shadow docket decision that doesn't have precedential value? I mean, I think we know where the courts would go if a case appeared before them today, so maybe that answers the question, but I'd be curious about your thoughts on
Well, I think that I'm going to be a functionalist here, a realist, I guess, and say the fact that the courts have all taken Tandon as precedential kind of answers it. Although I wish Steve Vladeck was here. Busy guy. But yeah, I mean, these are shadow docket cases, Tandon in all the COVID cases, which means that there was an oral argument in these cases. There wasn't 2 rounds of briefing, there was just 1 round of briefing. And yeah, I mean, I think these changes, they've sort of been spun as the court just deciding them based on the rules that were handed down. But I mean, the court really is sort of changing the law, or at least adopting one version of the law. And the fact that it happened on the shadow docket, I don't think looks that great.
So just for the students who haven't studied in this space, to understand then, if we're gonna accept the shadow docket decisions as binding law, then where we're at is a world where if government passes some kind of law or regulation, and there's even one secular exception to it, that suggests the law is not generally applicable, and the religious claimant then is most likely going to win. Seems to be the case. And you label this now, I think in your article, as second best free exercise. You see lots of flaws with this test, right? And I'd love to jump into that so we can really have a robust discussion.
Yeah, and you should also know Steve's sort of a defender maybe of this approach, or you've written a lot about it. So I think this is a really nice conversation to have.
I actually think second best is a really good descriptor, but go ahead.
Yeah. So I think there's a bunch of different problems. I mean, I think that result from this approach. I've always been an advocate of religious exemptions. I would go back to the regime that Sherbert and Yoder created, the old rule before Smith. Religious exemptions, should be given unless the government has a really compelling reason not to give them. But the court's current approach has a couple problems. One is that, what is this? I think that it creates a risk of the court going too far, and I think you see this in some of the vaccine cases that had come before the court. The court had one called Hochul versus Dr. A. The court didn't decide it on the merits, but there was a big dissent from denial of certiorari, or maybe it was a shadow docket case where they dissented. New York had a rule requiring healthcare workers to get vaccinated. But it made an exception for those who had medical needs. And Justice Gorsuch and I think Justice Alito wrote an opinion saying, well, again, following the logic of Newark, if you make an exception for those with medical needs, you need to make an exception for those with religious needs. And the problem, I think, with the court's methodology is the court's become totally blind to the reasons why we have secular exceptions, why you would make an exception for those with medical needs. I mean, you could imagine a world where, if you got the vaccine and you had an allergy to it, you would die. And the position of Justice Gorsuch in the case is, well, that's just something the government has to be blind to, right? Maybe you could ration the exemptions between those with medical needs and those with religious needs, but they have to be treated the same. And the question is, shouldn't that depend on the facts of the world? Shouldn't it depend on the reasons why we're giving this medical exception? And the answer is, it just can't. The way the courts developed the doctrine, that's just not something courts look at all. The other problem, or main problem, and this is something that I sort of wrote about, when I was a third-year law student, and this sort of developed into the piece that I eventually went on the market with and got a job, is that I think all of this ends up making religious exemptions a kind of matter. I said it was a sort of a matter of luck. So here's the thing. Go back to Newark, the case where the Muslim police officers are allowed to follow the Quran, their religious commitments. They're allowed to shave their beards. Ultimately, the reason why, again, was because the city of Newark had exempted those with medical needs from the requirement. And Judge Alito said, well, if you accept those with medical needs, you need to accept those with religious needs. But why did they exempt those with medical needs? Right? And if you dig enough, the answer is, well, there's this skin condition, which typically affects African American men, called PFB. And the hairs of the skin sort of curl in, and it makes it impossible to shave, very, very painful. But if you think about that a little bit, what it means, think about what would happen if this skin condition affected fewer people. Or think about what would happen if this skin condition just didn't exist at all. Well, in that case, then there wouldn't be a medical exception to the rule, and then there wouldn't be a religious exception to the rule. When Newark was decided, everyone took it as a big victory for free exercise, but I came to see it ultimately as just a fluke, right? Because of a skin condition, Muslim officers get to follow their religious commitments. Or in Lukumi, right? The fact that, enough people kill animals in sufficiently analogous contexts means that the Santeria have the right to religiously sacrifice animals too.
So is the problem that results in the concern over constitutional luck coming from the test that the Supreme Court has made? You describe it in your article as they're trying to make lemonade out of lemons.
Right.
Right? Is the problem with the test they've come up with, the idea that one secular exception makes it not generally applicable, or is the problem with the notion of a test that requires us to look at neutrality and general applicability in the first place?
Yeah. Trying to figure it. Yeah, I mean, I think they're both problems. I mean, I think general applicability is always going to suffer from these the problem of luck, and that's going to be true no matter how vigorously it's interpreted. And the more vigorously you interpret it to deal with these problems, the more you're going to give rise to other kinds of problems, right? Like, for example, giving religious exemptions in the vaccine cases, which I think is sort of really hard to justify. I mean, maybe that's why the phrase second best free exercise, which is the title of the piece, kind of works so well. It's not just that I think this doctrine is second best to the theory that was announced in Sherbert and Yoder. It's second best in the theory of a second best sense, in the sense that, like, you have a doctrine where if you try to fix a problem over here, you're going to create another problem over here, and that as long as you stay within the framework, within the paradigm, you can't solve the problems without creating other ones.
So I didn't tell him I was going to do this, so I apologize to him now that I'll just spring something on him. But you in your article, and I think generally, you argue that providing religious exemptions to folks is a good thing. Mm-hmm. And so I think that's why you're referring to this as second best. I assume the best would be just going back to the compelling interest test, right? If government at any level burdens someone's religious exercise, government has to pass the compelling interest test. So to leap into this question then of, are religious exemptions a good thing? I mean, we have some scholars in the room who would argue vigorously against that, right?
Yeah.
And there's a big doctrinal debate. Justice Scalia obviously disagreed when he wrote Employment Division versus Smith. I don't know if he would still feel that way today, but that's the position he took then. So why is the best approach to have a regime that generally would allow religious exemptions unless government can show that it has a compelling interest and has taken the narrow means to achieve that interest?
Yeah. Well, I mean, I think, for people who are religious commitments are really important. They mean a lot to them. I mean, they mean everything to them. And being able to follow your religious commitments where they lead, I mean, I think that's just really valuable. I mean, take a look at, there is a lot of skepticism about religious exemptions. But if you go back to a lot of the court cases, there's a lot less skepticism. Right? You look at the Native American church seeking to use peyote. I mean, these are religious traditions that go back centuries among a really tightly knit group of people who put really deep meaning on this. I think a secular case for religious exemptions can easily be made. I mean, I think religious exemptions are a form of hardship exemptions. We accommodate lots of other kinds of hardships, right? We accommodate disability, we accommodate pregnancy. I actually think we don't do a good enough job with those things. But I think of religious commitments along those lines. These are ways of protecting human vulnerability. Arguably,
the new test the court has adopted, some people have made this argument, is actually more protective of religious free exercise than what existed before Smith. Mm. Right? And as you point out, Professor Sager has pointed out that arguably prior to Smith, the court actually was not that protective of religious free exercise. Strict scrutiny really didn't seem to mean strict scrutiny. Now it seems to be the case that it does, and it's almost like a hyper-strict scrutiny, that it actually is fatal in fact now. So then I guess the question is, does your argument about constitutional luck still hold? If the reality is we live in a world where more often than not, the way the court's constructed this, people are going to get protections and maybe at a greater level than they were between 1963 and 1990.
Yeah, let's start with that first part of that. I mean, I think the point here might be about the irrelevance of formal doctrine. Because free exercise is really weird now. Before 1990, the court had a very protective test on paper that was not protective at all in practice. Or, I mean, I think it was protective sometimes and not others. And now we have a reverse situation where the doctrine on paper is very restrictive, very not conducive to religious exemptions, but the court seems to give religious exemptions all the time. In a way, neutrality and general applicability now as the court has conceived them under the current court, are more protective than strict scrutiny was then. In fact, I could go back to some of the cases that were decided in the 80s where religious observers lost under strict scrutiny that I think this court would say the rules weren't neutral and generally applicable. So I don't know what that means. I mean, I think one compelling criticism of my position is, your notion of strict scrutiny might be fine. But now you're advocating that the court strengthen a test that you're worried is already too strong. And I think that's a very legitimate criticism. Let me make it before somebody else does. I think the conceptual problem, though, that I would still point out is that the court, this neutrality and general applicability stuff, it's looking at the wrong factors. It's taking exceptions as being proxies for the things we really care about. And I think whether a rule has exceptions or not is not a very good proxy for whether a religious exemption should be given.
And do you think it's not a good, I want to flesh out what you mean by things we really care about. Do you think it's not a good proxy for whether or not there's maybe religious discrimination occurring?
No, I mean, I think neutrality does try to capture whether religious discrimination is happening. I think traditionally, the way we did religious exemptions, we took seriously how much it burdened religious practice, and we took seriously what the government's interest was in enforcing the rule nonetheless. Neutrality and general applicability answer those questions essentially by proxy, right? We take the exceptions in a rule as being a proxy for how strong the government's interest is. If there's an exception, well, we think the government's interest is a little less. If there's no exceptions, we think the government's interest is a little more. If you're going to think about general applicability and compare it side by side against strict scrutiny, I think that's how you would compare them. There's also no substantial burden inquiry when it comes to neutrality and general applicability, right? There's no threshold inquiry about how much does this burden religious practice. That's just sort of assumed. So again, we're not looking at the things we used to look at, and I think eventually that's going to make the court's approach unsustainable. I think, when Justice Gorsuch says in the vaccine case that the court's doctrines compel those with medical needs, right, those who have an allergy to the vaccine, to be treated like religious objectors, doctrinally he's right. But I think that's just unsustainable. So I think the court's going to have to back off it eventually.
Sure. Do you feel like, I mean, one of the criticisms, I think, I don't want to put words in your mouth in your article, but I think one of the criticisms you have of the Smith test, this idea of neutrality and general applicability, is the end result is that it seems to be incredibly malleable and gives judges lots of discretion to reach outcomes they want to reach. Of course, that's another critique of strict scrutiny, and the Schubert test that you're saying is the best test. I mean, that gives judges a lot of discretion, and they can use comparators to decide whether or not government has a compelling interest or whether or not government's efforts are narrowly tailored. So it seems like the problem exists in both places. How does going back to the Schubert test, why is that better than what we have?
It doesn't solve the malleability problem and the discretion problem. But I would put it this way. Justice Scalia decided in Smith that one of the reasons why religious exemptions had to go was because of the discretion that it gave judges and the malleability that it gave judges. But when we've reached the point that this is just as discretionary malleability as the old regime, then that rationale sort of dries up. I mean, I take that to be the fundamental reason why Justice Scalia decides the case he does in Smith. He says this way is much better than the old way when it comes to giving judges discretion and having non-malleable doctrines. But I think that just turned out to be not true. So, yeah, I mean, I think I could use this as an attack on Smith, but I think you're just also right.
So Professor Sepper and I were on a panel once, 18 months ago or something, and she pointed something out that I don't know if she still sees it this way, but she made the argument that it seems like the majority of the court wants to overrule Smith, but they just don't know what to replace it with. And so we're kind of dancing along in this limbo where we do have this very vague, unpredictable doctrine regarding the free exercise of religion. Do you think that's right? It just almost as it could be argued a political matter on the court, but just among the justices, they just don't know what to replace Smith with, so they're deciding not to formally overrule it. Yeah, I mean, as with many things, I think Professor Sepper's right.
3 justices on the court said they would overrule Smith. This happened in Fulton, which I think was the summer of 2021. 3 justices said they would overrule Smith. Then there was this bipartisan 3-justice group. It was Justice Breyer, Justice Kavanaugh, and Justice Barrett, who said, maybe we should overrule Smith. It actually seems wrong to us, but we don't know what the right approach would be. And so now it just feels like we're all kind of in limbo, waiting for the court to make up its mind on that, waiting for those middle justices to make up their mind on that. I mean, I think, what will drive them to make up their mind, I think, is if they're presented with a case that they can't that they want to give a religious exemption to, that they think religious liberty is fundamentally implicated in, but they can't give a religious exemption under neutrality or general applicability without completely making a hash of those things. And maybe it'll be, a California case coming up requiring religious organizations to include elective abortion coverage in their insurance plans. I think that would be a case where I think you'd have at least 5 justices saying, even if this rule is generally applicable, you can't enforce it against religious groups. But I think, we're in a limbo state right now. We're just sort of waiting to see what happens.
What about, I'm going to ask you one more question and then we'll open it up to the students. So if you've got questions, get them ready. Going back to the question of exemptions or not in the first place. Because that could clear up a lot of this mess. Maybe we have a regime where it's just exemptions are almost a guarantee unless the government can really get over a high hurdle. Or one where it's just exemptions we decide are just constitutionally unsound, they shouldn't be allowed in the first place. And as you know, some of the arguments against the idea of exemptions, you made your arguments as to why and how important religion is to people. But Professor Sager and others have made the argument that, look, lots of people have deeply held core values that are important to them that aren't necessarily religious. And so there's a fundamental unfairness for granting religious exemptions or exemptions to people who are religious if we're not going to be granting those same exemptions to people who might reach the same conclusion but on non-religious grounds through just logical reasoning, right? What about that unfairness concern about just exemptions generally?
Yeah, so I mean, I think this is an important question that has to be asked for religious exemption advocates, but I think there are responses. I mean, first let me say I don't think this is a problem with religious exemptions exactly. I think it's just a reason to expand, our protection of other kinds of secular commitments. I mean, I think, I talked about religious exemptions as a kind of hardship accommodation. I think we should be interested in accommodating all kinds of hardships, disability, pregnancy, and those kinds of things. I also think we have to have a sort of robust and broad view of what counts as religious. The court started this in 2 cases, draft exemption cases called Seeger and Welsh, where the draft exemption statutes for the Vietnam War formally required you. They wouldn't give you an exemption unless you said you believed in a supreme being. The court sort of broadly interpreted those statutes to protect secular conscientious objectors. I think those decisions are right. I actually think they're anchored now in RFRA, which should be interpreted the same way. I mean, I think there are ways of protecting secular conscientious objection. But the truth is I see religious commitments as being one of many different kinds of commitments that we could protect, but they're still one of the fundamental commitments that we should protect. Yeah, let me leave it at that. We might return to it in questions.
Okay, so with that, let's open it up to the room. Students get priority, but happy to call on professors if students don't have questions. And that's not a knock on professors, but I just want students to feel confident to ask questions that they have. So does anyone have any questions for Professor Lund? Yes?
So it seems we're kind of cycling through doctrinal messes where justices have a lot of power to kind of interpret what they're saying how they like. And I'm curious whether the strict scrutiny test or any other test really prevents justices from just making attitudinal decisions.
Can you go ahead and repeat questions so we make sure we pick them up for the video?
The question was, we've gone through these doctrinal changes. All of them seem to give discretion to judges, allowing them to make decisions, on visceral feels or sort of attitudinal bases. I think that might be inevitable with free exercise. We had this long period over 3 decades, where strict scrutiny was the test. And in other areas, when you have a general test like that over a period of time, it eventually gets broken down into a bunch of subsidiary rules, right? Like, the Constitution requires searches be reasonable. But the court doesn't ask whether in any given case a search is reasonable. Instead, it has a bunch of rules about when searches are reasonable and when they're not. And that never happened with free exercise. We never distilled the general down into a set of specific rules. And I think the problem is that the cases were just too different from each other. You know, one case would be about, you know, Muslim religious exercise in prisons. And then the next year it would be about Native American religious exercise, you know, on federal land. And because the cases were just so wildly different than each other, it was not possible to have a sort of, to break the general standard into a set of discrete rules. And Justice Scalia says in Smith, like, we're never going to be able to solve this problem. And giving judges this much discretion throughout the range of cases it's just too offensive to our concepts of what the judicial role is, and so we need to get religious exemptions, get rid of religious exemptions as a consequence. That's not my conception of the judicial role. I'm much more comfortable with judges having that kind of discretion. I think they've typically exercised it. I think I would defend that in more detail, but I do think Justice Scalia is not wrong about this. And, you know, Justice Ginsburg's dissent in Hobby Lobby repeats a lot of these themes. It's not the right, but the left sort of pressing this point nowadays. But they're not wrong.
Great. Other questions? Yes, over here.
Yeah, I was curious to see whether you thought that the current doctrine in the past couple of years, the religion cases or free exercise cases, were shaped in part by this kind of odd interpretation, this contrived interpretation of the Smith test, or do you think that the court would rule in a similar way if they had the ability to create their own test?
The ability to create their own test?
Yeah. So, like, to what degree is this a product of a certain interpretation of the existing test, or more attitudinal decision?
Well, they definitely could.
Let's repeat the question again.
Yeah, hold on. Say it one more time. I'll get it right.
Sorry, just gotta. Yeah, so, like, to what degree do you think that the court's past couple of years ruling on free exercise is due to the interpretation of the Smith test in the sort of weird way that you've discussed, versus like how the court would rule if they got to do their own test?
Yeah, so, you know, are the court's decisions now sort of based on neutrality and general applicability, right? It's conceptions of the old test, you know, versus its conceptions of the new test. The court could get rid of Smith easily. The court is changing a lot of constitutional law doctrines these days, right? I mean, you know, a case like Dobbs, I mean, maybe people wouldn't even notice very much if the court also just overruled Smith in the same term. I think, you know, if you look at the decisions in Fulton, you know, that three-justice concurrence that says, we don't like Smith, but we don't know what would replace it. I take those justices very seriously, because they could overrule Smith if they want. So I would take them at their word. They want to protect free exercise, you know, but they don't know what kind of doctrine to create, and they're kind of working through that. Yeah.
I mean, arguably, one of the things I think we learned from Smith is that if you make up a test willy-nilly without any input from anybody, which is what the Smith court did, you know, you're bringing on potentially 33 years of confusion, and lower court judges trying to figure it out. So it sounds like those three justices at least are a little bit wary of just creating another Smith test, right?
Yeah, I don't know if Justice Scalia and Smith ever thought we would be paying this much attention to those words.
Which I find hilarious, that he never thought lawyers would parse through the meaning of words. Okay, other questions? Yes?
I'm curious what you see the role of the justices' individual religious beliefs playing in their understanding of how to conceptualize religious exemptions, seeing that we have never had a non-Judeo-Christian judge on the court. And in the popular response to the COVID cases, I recall seeing a lot of discussion, rightly or wrongly, of people saying, well, if this wasn't Christian folks asking for a religious exemption, the court never would have granted it. And I'm curious what you see the role of their own personal familiarity with the religion that were requesting exemptions played into their decision to conceptualize the tests in the way that they did.
Yeah, I think that's I'm supposed to summarize the question again, aren't I?
But I think it's very, summary would be like, what role does their current religious beliefs of the justices play in their decision making? I think it's a tight summary of it.
That's a tight summary. That's a good question and deserves a nuanced and elaborate answer. I think it has to affect their decision making. I mean, all of our commitments affect all of our decision making in subtle and unconscious ways. You know, an oral argument in Hosanna Tabor, which was a case about the ministerial exception, about whether churches should be exempt from employment discrimination claims brought by their ministers. You know, Justice Scalia, at oral argument, he sort of expressed shock and alarm at the fact that the employment discrimination laws were neutral and generally applicable, and thus, you know, if you took them at their word, you know, the Catholic Church would have to ordain women. You know, he had. You know, the mentality, I think, was in the 1990s was that religious exemptions were for minority faiths. They weren't for the Catholic Church. The Catholic Church was never going to need religious exemptions. You know, its views about everything were just too mainstream for that to ever happen. And then, of course, that changes, and Justice Scalia is surprised at the effect of his decisions. At the same time, like, I would speak up for the conservative justices. I do think that they are interested in protecting religious exercise of all denominations. You know, Holt versus Hobbs was a case about Muslim religious exercise in prison, about a Muslim prisoner's right to wear a beard. Judge now Justice Alito went digging for that case and found it. And then it was a pro se petitioner, wasn't represented by anybody, and he called for more briefing, which spurred public interest groups to take the case. But he dug that case out. He wanted it. You know, because I think he's very interested in protecting religious exercise generally, but also, I mean, I think he sees the religious exercise of Muslims as being important too.
Yes, over here.
You mentioned with the case with the two Muslim police officers that the rule about beards, there was a medical exception already established, and the court used that as justification that it wasn't equal footing. But could you elaborate a little bit on how the court came to that logic? Because it seems that religious is a choice. You pick what you worship or don't worship, whereas a medical condition is more innate, not a choice.
So the question is, you know, religious needs and medical needs might be different because religion is in some sense chosen, while medical needs might not be chosen. This is a thorny issue in our field, right? The issue of religious voluntarism, right? And to the extent to which people choose their religious beliefs and their practices. To some extent, I don't think I have anything interesting to say here. I think it's hard. I think religion is partially chosen and partially not. I think, you know, it used to be that we were interested in protecting traits that we thought were immutable. Which was like, you know, when Lawrence versus Texas was coming through when I was in law school, right? You know, sexual orientation, mutable or immutable. And being a religion person, I've always been, you know, of the persuasion that it doesn't really matter whether it's changeable or not, that it deserves protection sort of either way. I mean, religious commitments are definitely chosen in a sense, right? I mean, we choose where we practice or what denomination we go to or whether we go to anything at all. We choose to change our minds. We convert every day from Christianity to atheism or from a non-theistic version of Judaism to a more theistic version, right? These are all changes that in a sense we're choosing. But at the same time, a lot of people experience religious commitments as not chosen. They would say, I don't believe what I want to believe, I believe what's true. Or I believe what the evidence leads me to believe. So there's just a lot of, we have to be really delicate with this.
And on the logic part of it, I would just say that I think at first off, Judge Alito treated religion as something more than just a choice. I think a core part of someone's identity, right? I think that was his basic assumption without actually stating it. Then the question was, how did he reach this conclusion? The logic of Lukumi, that's the 1993 case about animal sacrifice. That case, the court said, if there are secular exceptions that undermine the state's interest to the same or greater degree as the religious activity, then that makes the law not generally applicable. But they didn't say how many exceptions. So then fast forward to Judge Alito, and he's looking at this case and he says, the city has issued a rule that says police can't have beards because we want uniformity in the way our police officers look. So that was the government's stated interest, uniformity in the way police officers look. And then they had two exceptions to it. They had the medical exception, and they had the exception for undercover officers. The undercover officer exception did not undermine the city's stated interest, because the last thing you want an undercover officer to look like is a police officer, right? But the medical exemption did. And so Judge Alito looked at that and said, okay, you are treating, here you have an exemption that's undermining your interest to the exact same degree as the religious exemption. If you're going to allow that, but you're not going to allow the religious exemption, you have to have a good reason for why. You have to have a compelling interest reason for why, and it can't just be that you value the medical exemption over religion. Medical needs over religious needs. You can't do that. So that was kind of the logic they made. He didn't really delve into this question of, is religion a choice? I think that was the underlying assumption in his analysis. Would you say that's a fair characterization of that?
I really need to think about that. Yeah, I mean, I think so. I think so. I'm trying to think of places in Supreme Court jurisprudence where I've seen the opposite expressed, but I'm not sure I can. Let me think about that.
Other questions? Any professors in the room want to get in on this and make Professor Lund's life really hard? Professor Sutton?
Yeah, abortion bans, Chris.
Whether they're new? Oh, okay, go for it.
Right, so we have abortion bans. Could take states like Ohio, you have a 6-week ban, you have fetal anomalies, obviously before 6 weeks also permissible abortions. You have the fact that pregnant people can't be prosecuted under the law, so a pregnant person who self-manages abortion, there's no one to criminal charge, right? You have rape and incest exceptions. So Tandon seems to really very clearly require exceptions, right?
Yes, I think that's right.
Great, can you repeat the question?
Yeah, so this is Professor Sepper's pointing out how the rules forbidding abortion might not be neutral and generally applicable, right? They have all of these exceptions, and so if you're going to allow an exception for these kinds of reasons, right, for rape and incest or for fetal anomalies or abnormalities, I don't know.
Anomalies, either one.
Okay. Or self-managed abortions that I didn't know about. But you're making all these exceptions, why don't you need to make a religious exception, right? And there are suits now brought by Reform Jews, I think of the most, who say, we have religious commitments, that in some situations the religiously appropriate thing is to have an abortion given the situation. I think under the doctrine as it is, right, those claims can and should succeed. I think for the same reasons as in the medical or vaccine cases that we were talking about, right? If you can't look, the court says, you can't look to the reason why the exemption was given. You can't compare the importance of the religious exemption against the importance of the other exemptions. You can only ask how much harm they do to the government's interest. And an exception for rape and incest, for example, have the same consequences to the government's interest as an exception for a religious person. So yeah, I think that's right. I think there might be a problem on the substantial burden side, which is that it's not clear to me necessarily in all these cases where there's a substantial burden. I think what you need to show, you don't have to ever show religious obligation, but you do need to show that some sort of religious motivation, that the right thing to do, or the appropriate thing within Reform Judaism is to have an abortion in this context. But you convinced me, I think, that those situations actually do exist, that there are substantial burdens, at least in some cases.
So let's assume that fact pattern.
Okay.
Let's assume that we have a plaintiff whose religious beliefs do not just permit abortion, but given the particular circumstances, say consulting with their rabbi or whatever, actually require it. That it's a commandment of the divine that in this situation you should get an abortion.
Right.
And it does seem like the logic of Tandon and where the court has gone would require that, assuming we're in a state where there are exceptions. I don't know if there are states that are making no exceptions. It seems like states have exceptions. And I go back to what I said earlier, where I think it's almost impossible to make a generally applicable law. I'll emphasize almost, but it seems very difficult under the court's new test. So the logic of it suggests they should be able to get the religious exemption. Now, let me ask you the legal realist question. What do you think judges are actually going to do? We have some nonprofit law firms out there attacking these claims for lack of sincerity, which, you know, I think some of these claimants can actually prove a very real sincerity.
Yes.
So let's assume it was sincere, you get over the sincerity mark. What is a judge going to do with that? Do you think they're going to apply tandem faithfully, or are they going to find reasons to dance around it and further manipulate the test?
I think they're going to find ways to dance around it. I mean, I think that these plaintiffs are sincere. I haven't been well disposed towards the folks arguing against sincerity. And I think, you know, for the reasons we just talked about, substantial burden is clear. You know, in theory, you know, if you went back to Sherbert and Yoder, you would talk about compelling interests at that point. But the way the court has structured neutrality and general applicability is a lack of general applicability essentially means a lack of compelling governmental interests. And so if you take these rape and incest exceptions, you know, seriously, as I think the doctrine would compel you to do, then I think you're going to say there's a lack of compelling governmental interest. Because if there was, then you wouldn't have a rape or incest exception at all. Now, from the legal realist point of view, I don't think courts are going to do this. I mean, maybe some liberal courts would, but I don't think most conservative judges would go for this. You know, if the Supreme Court ever gets a case where a federal appellate court gave a religious exemption, it's going to put them in a really tricky spot. I think what they're probably hoping is that they never have to take the case themselves.
I mean, it's interesting because you see these groups who are pro free exercise exemptions making the sincerity arguments, and yet
I think it's a bad look.
Traditionally, the argument has been, we don't want judges looking at sincerity, right?
No.
It is not a judge's place to be digging into the sincerity of someone's claimed religious beliefs. So it's this weird flip that's occurring. And I'm wondering how that's going to affect all the doctrines that...
It is. So some conservative public interest groups have been attacking sincerity in these religious exemption cases when they've defended religious exemptions. In other cases, I've worked with them defending religious exemptions. In those other cases, I think this is a mistake they're making to attack sincerity. There was I mean, I think you saw this dynamic in Ramirez versus Collier, which was a case about executions and whether you could have someone in the chamber.
That was a Texas law case, Chris.
Yeah. Oh my gosh, of course. I'm in the right place to this.
You're in the right place. Go ahead, sorry.
Yeah, but it was only Justice Thomas that attacked sincerity, right? I mean, which was a surprise. I didn't see that one coming, but he doubted the sincerity, the religious sincerity of the inmate, which I thought the majority responded to precisely the right way, but it does reveal that this dynamic changes. And there are advocates of religious exemptions who want a very rigorous sincerity determination, maybe because they believe in religious exemptions, then they think the whole project will be unstable if anyone is presumptively deemed sincere.
Professor Grout,
I'd say that the Texas SG's office in the Ramirez case also went really hard on sincerity, which I think a lot of people would find jarring as they're kind of the bastion of conservative legal thought when, you know, it's a government in exile. And to see them go so hard against sincerity in the religious liberty case, I think was notable. My question is to maybe push back on the idea that Gorsuch is right in the mandate, the vaccine mandate cases, and that general applicability only gets you to strict scrutiny. It only gets you back to the Yoder framework, and it would seem very easy. I'm sure some people would disagree, but I think it would be easy for a government to put evidence in the record that given the amount of people you would expect to utilize a religious vaccine opt-out, you know, now, maybe it was different back when it was only very small percentage of the population was utilize that, like in school vaccine mandates that have had that for a long time. But you could, like the state of New York would be able to say, we have a very small amount of added public health harm coming from the death or serious health exception. We would have to allow many more exemptions under the religious mandate, so we do have the least restrictive means, or we have narrowly tailored the denial of the religious exemption in favor of the compelling interest of public health and safety, because so much damage to health and safety would come from the religious exemption.
I could see that. and it makes sense to me, I think it would be a doctrinal innovation. I think it would be the court now changing the principles a little bit. Traditionally, I think if you look at lower court cases, and especially if you look at Lukumi, the lack of general applicability was sort of taken automatically as a lack of a compelling interest, right? If you really had a compelling interest, you would apply this law to everyone and not just the religious observers. And if you look at Justice Gorsuch in the medical and religious vaccine cases, he's also open to compelling interest. But he would say if it's not generally applicable, you need to ration exemptions equally between the permitted secular uses and the religious use, which also wouldn't be this exactly. So I think you're right. This is one way the court could try to fix the mess.
Do you think Gorsuch is right that that's the best reading? Is that the rationing is the best reading of the doctrine?
No, I wouldn't do that. But the move that Tandon made, where you say you don't look at the reasons why the secular exception was given, because you don't want a free will balancing between how important religion is and this other thing, that commitment, I think, leads to the Gorsuch position. I think that commitment was a mistake.
So on that note, would everyone please join me in thanking Professor Lund? And thank all of you for your questions and comments. Really appreciate it.
Yeah. Thanks.